Was that enough time?
Yes, we were not successful in coming to any agreement. Is Ms. Young available on the other case?
Yep, I'll put you back in.
All right, thank you so much.
You're welcome. Miss Young, can you hear me? Miss Baker, did Miss Young join you or did something happen? Because I had to readmit her.
Yes, she dropped out. We do have an agreement in that matter, so we can just put it on the record, I believe.
Okay, all right,
All right.
thank you.
Thank you.
We have an agreement in MDB.
Good morning, Your Honor. Denise Baker on behalf of plaintiff. There is no agreement in that matter.
Okay, there is an agreement in some other matter.
Yes, the
Okay.
Win Obstetrics versus Shakia Young.
And where is Ms. Young?
She had dropped off accidentally, I believe. I
Oh,
don't know.
no, she's here. She's just not connected with her audio. See if we can get her to connect so we can get the matter called and hopefully. She's not responding. So what I will do is put her out and hopefully she'll see that and make an effort to reconnect.
Okay.
Okay. And as for the other matter, 2020 GC MDB versus Martin and Nabinger, have the parties spoken this morning?
Yes, we have, Your Honor. And unfortunately, we were unable to come to any agreement.
Thank you. Ms. Baker, I have your appearance. And for the defendants, would you state your names for the record, please?
Nicholas Nabinger.
Ebony Nabinger.
Thank you. Today is the day and time set for a hearing on the plaintiff's motion for summary disposition. Oh, Ms. Young,
Yes.
I'm sorry, Mr. and Mrs. Nabinger, if you would just wait one moment. This is 223463 GC. This is Wynn Obstetrics and Gynecology versus Young. Ms. Young, turn your video on, please, and state your name for the record.
Shakia Young.
Thank you. Today is the day and time set for the pretrial in this matter. The parties have had an opportunity to speak, and Ms. Baker has advised there's a settlement in this matter. Ms. Baker, the terms of that.
Yes, good morning, Your Honor. Thank you. The parties have entered into a settlement agreement, and a stipulation and order for conditional dismissal was forwarded to Ms. Young. The settlement amount is $520.21 to be paid on or before November 20th, 2022. Upon receipt of that payment, plaintiff will file a dismissal of this matter with prejudice. However, if the defendant fails to make that payment, then we would file an affidavit of noncompliance with the court, and judgment would enter for the full amount of $845.56 plus court costs of $120.21 and the statutory attorney fee of $75. Ms. Young, we did speak and has indicated that she has signed the stipulation in order for conditional dismissal, and will email that document back to us, and we will submit it to the court for entry.
Thank you. Ms. Young, you were able to hear Ms. Baker just now?
Yes.
And ma'am, it's your understanding and agreement that you will pay $520.21 to the plaintiff by November 20th, 2022, and this matter will be dismissed with prejudice?
Yes.
And you have received an email from Ms. Baker with a conditional dismissal with those terms?
Yes.
Ms. Baker, what I'll do is note the court file that you will submit the fully executed conditional dismissal. The court will leave an adjourned pretrial on the docket. We'll set the adjourned pretrial date as December 6, 2022 at 9 a.m. back on Zoom, back with me. Ms. Young, that's just a control date to make sure that the paperwork gets filed. Once this court receives the executed conditional dismissal, I'll sign it, and then copies will be mailed to the parties at the addresses in the court file. Ms. Young, if you receive a copy of that conditional dismissal with my signature, that means you don't need to come back on December 6th, okay?
Okay.
Anything else, Ms. Baker?
I have nothing further in that matter, Your Honor. Thank you.
Thank you, Ms. Young. You have a wonderful day. Thanks for logging back on.
You too. Thank you.
Thank you. This is a recall of 222020 GC. This is the day and time set for the the final pretrial and motion for summary disposition. The court has received and read the plaintiff's motion in its entirety. Mr. and Mrs. Nabinger, did you file a written response to the motion?
Yes. We filed the written. Thank you.
Mr. and Mrs. Nabinger? Ms. Baker, did you receive a written response from the defendant?
We have not, Your Honor.
Let's see if their connection improves. Oh, looks like we lost them completely.
The benefits and challenges of Zoom.
I'll take it because those people are persistent in trying to get reconnected. So we'll see. And I'm looking on our ROA to see if there's a response received and noted. Actually,
I don't know what happened.
you're back. It seemed like you froze. You had a little bit of a connection issue, but you're back. Ms. Baker, in their absence, the court's reviewing the file that specifically the dates. The court is showing the motion as being received on October the 18th, which was just 2 weeks ago.
We filed the motion, well, we mailed it to the defendant on October 10th and mailed it to the court then as well. As indicated on the
Mr.
proof of service.
Mr. and Mrs. Nabinger, you received a copy of the plaintiff's motion for summary disposition.
We only received one paper from them, and that was paper telling us to admit to guilt.
That was the discovery request. There should have been something received after that.
I have not
The
received
court
anything.
received it on the 18th. You should have received it sometime maybe between the 13th and the 18th, 19th of October.
I have not received anything else.
And just to confirm, you're at 36845 Sibley Road in New Boston.
Yes, ma'am.
That's the address that plaintiff indicates they used to serve you. The motion is the same address they would have sent the discovery request to.
And we sent a copy to each defendant as well. So 2 copies of the motion were mailed out, as well as the discovery requests, which haven't been answered either.
We didn't receive that.
We only received one where they wanted us to answer all them questions, admitting that we are guilty.
It's not a matter of guilt, Mr. Nabinger, just so we're on the same page. It's responsible. But if you receive that discovery request and plaintiff used the same address to serve the motion, it'd be unusual that you did not receive it.
Yeah, I haven't received that. That's the only thing I haven't received. I wish I knew what they were talking about. Oh. This is why.
Mr. Nabinger, an issue in the plaintiff's motion, at least in part, is that you failed to respond to the discovery request.
Well,
You've
that
now
that
indicated that you
paper-
received.
the one they sent us, like we weren't sure how to figure out how to, to answer that. We tried to get an attorney, but every attorney place we went to or talked to for legal aid and everything, it was a conflict of interest. We didn't know what else to do. We didn't want to answer questions that we didn't understand.
We went to court.
We even went to the court. They gave us numbers for attorneys to help us, and everything was always a conflict of interest.
The issue is that the discovery request served on you have instructions that indicate that your failure to respond to them caused them to be deemed admitted. Ms.
Well, that's-
Baker, is there something you'd like to say, ma'am?
What's that
Uh,
paper?
Just in adding that, the court did grant us discovery at the pretrial on August 2nd of 2022. The discovery requests were properly served and they have not been responded to. And according to MCR 2.312B1, the statements contained in the request for admissions are deemed admitted.
See, either way we went. I'm not understanding.
What is it that you're not understanding, sir?
Like my understanding with that paper is like if every question that was on that paper, please admit. I wasn't gonna admit to anything that I wasn't guilty of. And now my understanding is because we didn't fill that paper out because we didn't understand it properly. Now we're basically admitting that we're guilty and we're not.
What it actually is, Mr. Nabinger, is that when you appeared the last time on August 2nd, 2022, and the plaintiff asked for discovery, what I typically say is discovery is granted for whatever the period of time is, and in this case, it was 60 days. And because you're unrepresented, you're representing yourself, you might not know the rules. And so what I typically say is, if you receive something from the plaintiff, respond to it. If there's something you want from the plaintiff, you have to send your request to them in writing. Anything you send to the court, you also have to send to the plaintiff. That is the usual statement that I make to parties. And when you here on the record this morning indicate to the court that you did in fact receive discovery that you didn't respond to, and the discovery specifically says that within 28 days after you are served, you need to respond to you need to provide your answers to the interrogatories, request to admission, request for production. The very next sentence says that requests for admission will be deemed admitted if responses are not mailed within 28 days after they are served. So although the court can't give you legal advice, the document that Ms. Baker's office served on you is clear and you acknowledge receiving it. Plaintiff's motion is based on, in part, on the fact that you had discovery sent to you that you didn't respond to. And the court orders are very clear, sir. The court is required to deem all of the requests for admissions to be deemed admitted because you did not respond to them. And based on that, the court has to grant the plaintiff's motion for summary disposition, which asks for entry of judgment in the amount of $8,200. They made a request for the filing fee of $75, $20 motion fee, service fee of $51.83, statutory attorney fee of $75 for a total judgment of $8,421.83. The court is entering that judgment this morning. The copy will be mailed to you at the address that is on file with the court. There is an outstanding issue that the defendants delivered to the court. 7 envelopes that contain pictures of the properties, the Studebaker and the Cadillac properties. And Mr. and Mrs. Nabinger, are these the only copies? Or are these the originals?
No, we have copies.
The
They
same
have
copies.
copies.
So if the court does not need to return them, they will be maintained in the file. Anything else, Ms. Baker, on behalf of the plaintiff?
I have nothing further, Your Honor.
Anything else, Mr. and Mrs. Nabinger?
Yeah, how can I refight this, or what can I do? Because this ain't right. I didn't understand the papers.
And we tried to ask for a lawyer.
We tried everywhere to ask for a lawyer to help us because we have 7 kids at home. We can't afford a lawyer. Nobody wants to help us. It's like he's talking to every lawyer because he is a lawyer, and nobody will help us. We don't understand all this stuff that they're saying. It's like if we filled out the paper, we admitted to guilt. A lawyer looked at the paper and said, if you fill it out, you're admitting to guilt. If you don't fill it out, you're admitting to guilt. He's like, either way, you're admitting to guilt. That's not fair to us. We didn't do anything wrong. We did what we were supposed to do. I turned in all the evidence, all the pictures I was supposed to turn in that, show what was what, that we didn't owe him this money, that I did work for him, doing all these houses for him for the rent. And now all of a sudden I have to pay him more money. So I just lost all this money that I worked on, remodeled 5 houses for him.
Mr. Nabinger, what happens is when you file something with the court, it has to be clear what your position is. And when we were here in August, I asked you to provide to the court what it was that was referenced in your answer, because your answer does make allegations that there was this outside arrangement for repairs and work. And then you submit the pictures, but that's not responsive to, that's not a response to what the complaint was. And then when the discovery goes out to you, the discovery has instructions on it. And I know that they're not necessarily the easiest to read, but it's very clear that you have to do something within 4 weeks. And if you don't do something, it's to your peril. And if you didn't admit it, if under each question you said, no, that's not true, that would have at least got us to this final pretrial, we have another conversation. But when you don't respond, there are court rules that say that the court can't do anything except deem the request to admit admitted. So I can't give you advice on where to go next, but if you have the phone numbers for legal aid, I would suggest that you continue to call them. The State Bar of Michigan has a lawyer referral service. You can reach out to them.
We've reached out to
At
all.
this point,
It just doesn't make sense anymore. It's like, we did all this work. We did not trash his house like he shows in his papers. We sent pictures showing that we did not trash his house. And now this man is getting all this money for something he does not deserve. And it's okay with everybody. And it's not okay. This man is taking advantage of people, and the court is letting it happen.
Mr. Nabinger, the court is not letting anything happen, and it's not a question of somebody getting away with something. There are rules that the court has to follow. There are court rules and there are statutes.
Sorry, Judge, I didn't mean to interrupt you. But it's okay for them to send us papers that knowing that we won't understand. And either way, it admits to guilt.
Mr. Nabinger, I'm going to end this hearing because there's other cases waiting, but I'm going to ask you to look at the discovery. The very first paragraph says, do something within 28 days. And even if you don't do it to the letter correctly, if you respond to it, it preserves your place. And I know it's difficult when you think it's lawyer language or legalese and you don't understand every detail of the paperwork, but you have to do something. It's not a question of the plaintiff getting away with anything. It's you have to participate in the proceedings. I can't help you. That's not, and the court staff can't help you.
That's fine. Have a good day. Thank you, Judge.
You too, sir. Thank you. Anything else this morning, Ms. Baker?
That's it, Your Honor. Thank you.
Have a good day.
You too.
Good morning, Mr. Barta.
Good morning, Your Honor. How are you?
I am super. How are you, sir?
A little hungover from the sugar, but I'm okay.
Hungover from the sugar. Were you in somebody else's candy stash?
I'm not saying anything. Better to plead the fifth.
Actually, Mr. Lynch has an earlier case than you. He's on the 9:15. I see you at 9:30. Good morning, Mr. Lynch.
Morning, Your Honor. How are you today?
I am super, sir. How are you?
Pretty good. Pretty good.
Is there anyone here representing Lily May Construction? Mr. Lynch, my rule is 15 minutes after the scheduled start time. We're not quite at 9:30 yet, so if you can sit tight for another 7 minutes, I'll get the case called and get you
I
on
can
your
do
way,
that.
okay?
Certainly. Thank you.
Thank you. Mr. Burke. Have you been in communication with Mr. Ivanchek?
Yes, Your Honor. In fact, he and I were just emailing and I think we resolved our case. I can message him right now and tell him to log on.
He's still early. It's 9:24 by my clock, and the last time we were here, I knew that some of the bills had been approved and some others were being resubmitted. So I got the impression that we were going to have this resolved. So as long as he's here, 9:45-ish at the outside, we'll be ready to go.
He just emailed me and said he's logging in now, so I'll
I'll keep an eye out for
I'll
him.
mute myself and wait until you call me, Your Honor.
Thank you.
Thank you.
Mary Ann. Good morning, sir. This is 220503 GC. This is Beaumont Health versus Tiffany Fleeson.
Yes, Your Honor. This is Hal Burke, P69068, attorney for Beaumont Health on this case.
John Ivanchek, P66157 for the defendant, Your Honor.
Thank you. Mr. Vanchik, before you joined us, I was saying to Mr. Burke, the last time we were here, it appeared that the parties were pretty close on resolving this matter. Where do we stand this morning, Mr. Burke?
Your Honor, you are correct on what you said. In fact, I think we're even closer. And Mr. Ivanchek and I just agreed to a payment plan and a proposed consent judgment that I'm going to prepare and email to him. Would you consider giving us approximately, I was going to say 10 or 15 days to get that to you? I'm going to have it done and try to get it emailed to him today, if not early on Wednesday.
What I will actually do, Mr. Burke, is adjourn the final pretrial again to December the 6th at 9 a.m. That's just to keep this case from falling on the show cause docket or the failure to the no progress docket, actually.
Thank you.
Thank
If
you.
you have that consent judgment signed and received before December 6th, of course, you don't need to appear. We'll just sign and send the copies out to you.
Okay. Hal, we have two different files, this one and the other one that you guys are supposed to send to me, but I don't think I ever got. So we're doing consents on both of them?
Yes, they're being prepared after receiving your email. They're being prepared right now. My only request is maybe you can email me what you believe the balance to be on this one right now.
I would love to tell you what I think that balance is, but I have no idea. So, whatever you guys come up with, I think we can kind of work out. Okay,
Thank you.
yeah, just tell
Anything
Rich.
else in this case, Mr. Byrd?
Would you say that again, Your Honor? I apologize.
I said, anything else in this case?
Nothing else. Sorry to take your time. Thank
No,
you.
you're not taking my time at all. I was just gonna suggest if you and Mr. Evancheck had some other things to talk about, we can move you into a breakout room where you can follow up with each other offline so I can get these other cases called. Oh, Miss Gleason's here.
I appreciate that. Thank you.
Um, if you don't mind me, Tiffany, we're all set. So I'll give you a call really quick, okay?
Okay, thanks.
Yep, thank you. I think we're all set, Your Honor. Thank you.
Thank you, Your
Everybody have
Honor.
a good day. Thank you.
Thank you.
This is 220741 GC. This is Travelers versus Lily May Construction.
Morning, Your Honor. Stephen Lynch, P70211. I am appearing for the plaintiff in this matter. And today is the date and time set for a motion of show cause for Mr. Aaron Bragenzer. He's the corporate representative, member, incorporator, resident agent of the defendant Lily May Construction. And this is the, like I said, the show cause for him failing to appear at a creditor's examination.
Show cause was actually scheduled at 9:15. It's now 9:30 by this court's clock. Neither the named defendant nor the agent, Aaron Bagenzer, have appeared this morning. Mr. Lynch, how would you like to proceed?
At this point, Your Honor, this is the second order that he has disobeyed. I'd appreciate if a bench warrant would issue for his arrest, a nominal cash surety bond of $500.
Thank you, sir. Defendant having failed to appear, bench warrant shall issue. You actually mean 5,000, 10%? Is that what you're looking for?
That's fine, Your Honor, yes.
Okay. Thank you. 5,000, 10%. And do you have the particulars for the bench warrant, sir, to submit to the clerk's office?
I'll be able to find them and I will submit that to the court.
Thank you, sir. The file will be downstairs waiting for your paperwork. Have a good
Very
afternoon.
good. Have a great day. Thank you.
On the docket, we had 222306 GC, that's Carl Dolans versus Dave Olson, doing business as Olson Cement. It appears on the court's docket as a pretrial. There is an order signed from October 13th that contains therein a dismissal with prejudice of this matter. File will be back downstairs with that indication. Mr. Barta, have you spoken with Mr. Allen this morning?
I have not, Your Honor.
He's here. Mary Ann can get you moved into a breakout room.
Sounds great. Thank you.
You're welcome. Mr. Allen, please turn your video camera on. This is 223769 GC Portfolio Recovery Associates versus Curtis Allen. May I have your appearances, please?
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of the plaintiff.
Good morning, Curtis Allen, the defendant.
Good morning, sir. Today is a day and time set for the first pretrial in this matter. There was a motion for summary disposition received on October the 19th. Mr. Barty, you've had a chance to speak to Mr. Allen. How are we proceeding this morning?
Your Honor, I think we're just, we did not resolve it, so I think we just need scheduling. If the motion for summary disposition is not scheduled for today, which it sounds like from when the court received it, it may not be, then I would ask for a scheduling order and to set that motion date if the court, but if the court is inclined to argue that motion, I am ready also.
Mr. Barta, the court's position is that there was not sufficient notice given to Mr. Allen, considering when the court received it. The court will adjourn the motion for summary disposition to December 6th at 9 a.m. Back on Zoom, back with me. Mr. Allen, did you receive a copy of the plaintiff's motion?
Can you say that again, please?
Did you receive a copy of the plaintiff's motion?
I did. I'm looking at it now.
Okay. Sir, when we come back on December the 6th, if you're going to respond in writing, please serve the court and mail a copy to the plaintiff's office. If you're able to speak to the plaintiff before you resolve the case, the parties can sign an agreement and submit it to the court. You made allegations in your answer, sir, that this was not you, that you did not live at the address. So I guess we'll take that up on December 6th at 9 a.m., okay? Anything else, Mr. Barta?
Are we unable to resolve it this morning? Because I want to point out something that I think will fix things pretty quickly.
What is it, sir?
In his motion that he filed, everything that he says is based off of this contract in Exhibit 1, and then you go to the exhibit and it's simply not there. So if I could just see the contract and the terms of contract, if it's my signature, you know, we could resolve this pretty quickly.
Your Honor, if and excuse me if it's not, so I think we can bring this up on the 6th, but if it's a contract that Mr. Allen needs, I would just like to point out that the law in Michigan is that if a billing statement is mailed to a customer's home and the customer makes a payment on that bill that was mailed to the home and does not dispute anything within 30 days in writing, then the contract becomes actionable between all the parties for the balance that's at the top of the bill. So more likely than not, on a purchase debt of this kind, he will not be receiving any contract with a signature on it. But in fact, he has received the bills that were attached to our motion for summary, where payments were made with a balance at the top.
Can I respond?
We're not arguing the motion right now, Mr. Allen, and that's why when you said it would be a quick way to resolve it, we don't do things that way. When there's a written motion, you can respond in your written response or be prepared to argue it on December the 6th at 9 a.m. back on Zoom.
Okay, thank you.
Anything else, Mr. Barta?
No, ma'am.
Anything else, Mr. Allen?
No, ma'am.
I'll see you next month. Have a good afternoon.
You too.
Thank you. Anya,
Hello.
good morning.
Well, my name is Janice Danzy. I'm sorry, I'm logged in from,
You're fine. Your case is scheduled at 9:45. I have not seen anyone from Mr. Zuba's office, but if you sit tight,
okay,
this course policy is 15 minutes after the scheduled start time. So if he's not here, no one else from his office is here at 10 o'clock, we'll call the case and get you on your way, okay?
okay.
Thank you, ma'am.
Robin, I'm going to put you, good morning.
Good morning.
I'm going to put you in a breakout room with Miss Danzy.
Okay, thank you.
Are the parties ready on Ford versus Dancy?
We are ready.
This is 224553 GC. This is Ford Motor Credit versus Janice Dancy. May I have your appearances, please?
Good morning, Your Honor. Robin Stradowski on behalf of Ford Motor Credit Company, P number 71195.
Ma'am, state your name for the record, please.
Good morning. My name is Janice Danzy.
Thank you. Today is the day and time set for the first pretrial in this matter. The parties have had an opportunity to speak. How are we proceeding this
Yes,
morning?
we have. We have come to an agreement. Ms. Dancy is going to pay the balance on this judgment or on this account by paying payments of $100 a month beginning November 15th and then by the 15th of each month. And we will prepare a consent judgment with those terms. Would you like us to mail that directly to the court, or do you need to get the signatures on there first since we've already put the terms on the record?
You haven't put the terms on the record. I need the dollar amount and the filing fees and everything else, so we're all on the same page.
Okay, let's see. The total amount is, I'm gonna get that. Where's fees yet? Total amount that we have is $4,406.90. That's the $75 for the filing fee and $75 statutory attorney fee. We never got the attempt fees back from the process server yet, so that's all we have right now. So the total amount would be $4,406.90.
Ms. Dancy, you were able to hear the attorney just now?
Yes,
And ma'am, you wish to agree to entry of a judgment that indicates that there is a principal balance due of $4,256.90, a $75 filing fee, and a $75 attorney fee.
yes, I agree.
And ma'am, you'll pay this amount at $100 per month beginning on November 15, 2022.
Yes,
And you understand that because the parties do not appear in person, there is not a signed judgment, so that the plaintiff's office will submit it to the court and the court will enter it as if both of you signed it this morning.
yes,
And that's what you wish to agree to.
yes, it is.
Do you have any questions, ma'am?
No, I do not.
The plaintiff's office may email that over to the civil department or mail it in. Doesn't matter to me one way or the other. I'll sign it. And Ms. Dancy, you'll then get a copy with my signature. And unless there's anything else, this case will be deemed resolved in its entirety. Anything else on behalf of the plaintiff?
Your Honor, if I could just have somebody give me the email address that we can send that to.
It's civil@34th District Court -mi.org.
Thank you. I'll email that to the
You're
court.
welcome.
Nothing further.
Ms. Dancy, we're all set. Have a great day.
You
All
too,
right.
thank you.
Thank you. Have a good day.
Bye-bye.
You too, ma'am. Mr. Horka.
Hey, Judge, can I just get one moment?
I figured you were somewhere else. That's fine. Good morning, Ms. Hart.
Good morning, Your Honor.
How are you, ma'am?
Good, thank you. How are you, Your Honor?
I am super.
We have the Burke matter together, but we are withdrawing our motion. So
This is 223086 LT. This is Metro Commons versus Gary Allen Brook. May I have your appearance, please, ma'am?
yes, Your Honor, Sumchit Hart, P69542 on behalf of Metro Commons. This is our motion for issuance of an order of, Your Honor. I got an email from the property manager this morning. Mr. Burke has since vacated, so the issue is withheld.
Thank you, ma'am. Anything
Thank you.
else this morning?
Nothing additional. That concludes it for us, I believe, here.
Thank you. Have a good day.
You as well.
Thank you. Mr. Horka, your change in appearance caught me off guard.
I like to keep everybody on their toes.
Oh, this is 220223 LT. This is Walter Sikowski for the estate of Tona Rouse Hartwell versus all occupants at 49066 Tagoti Pass in Belleville, actually Van Buren, but 601 half dozen the other. Mr. Horka, the court has this on the docket as a hearing on an application for eviction, but I don't have either an application or a filing fee, so I'm not sure how this got scheduled.
Good morning, Joe Horka, P75969 for the plaintiff. Just been my experience that when you file a motion for the eviction, that $20 check covers the writ itself, but I'm happy to submit another filing fee if necessary.
I don't have any paperwork. I don't have paperwork and I don't have either one. It's not just the money part of it. The money part's an aside. I don't have a motion or application for eviction.
We sent it in back on October 12th, Your Honor, but that doesn't change the fact that you don't have it right now.
Because if there were a filing fee, they would have at least run the fee to post it to the file, and I don't have it. So I'm not sure. Mr. Horka, let's say this. Case was scheduled at 9:45. My policy is usually 15 minutes after the scheduled start time, but we're bumping up against 9:58, and I have not seen anyone from the property. And we have previously had Tiara Brewington and then Saladin Stanford appearing as occupants from the property. Sir, they have not appeared this morning. Is it still your client's desire to retake the premises?
It is, Your Honor.
What I will do is I will indicate on the file notes that your request for entry of an order of eviction is granted, and we'll see if it's downstairs somewhere, maybe just hasn't made it up with the file. If they find it and get it up to me, I'll sign the order. Otherwise, I'll have them reach back out to your office to resubmit a new one and the filing fee.
Judge, out of abundance of caution, in case there was a mailing issue on this, can we adjourn this like 2 weeks to make sure everybody got the paperwork they were supposed to get?
I won't fight you, Mr. Horka. It is the first Marion. Oh, let's look what the 15th looks like. I think there's stuff scheduled that day. Why do I feel like there's Sarah stays on the 15th, Marianne?
Let me check.
Yep. Yes. That's a civil day and we have some Sarah stuff. So if you want to do, we can adjourn this over to November the 15th at Are you somewhere else already that morning?
I'm sure, but it will work out.
Give me 1 second just to look at the. Oh, Mary Ann, I start working on the jury instructions for the 14th.
Are you looking for a time? Is that which,
I was looking for a time, but it was just slow coming up. Can we say 10:30 on the 15th? Hearing on plaintiff's request for entry of order of eviction is adjourned to November 15, 2022 at 10:30 a.m. back on Zoom, back here with courtroom number 1. Anything else in this matter, Mr. Horka?
Not at this time, Your Honor.
Thank you, sir. Have a good day.
You too. See you.
Good morning, Ms. Everett.
Good morning. My apologies. I was in court at a Judge Green's court and just got out.
You're fine. The attorney appeared in this matter indicated that Mr. Brook has vacated the property.
Yes, he has.
Was there anything else you needed this morning?
No, thank you very much.
We're all set, ma'am. Have a wonderful afternoon.
You as well. Thank you.
Thank you.
Bye.
Mary Ann, that is all that I have. Our docket is done. It is 10:01. This court will stand adjourned.